Good morning and welcome to the Judicial Committee of the Privy Council. Today we are hearing an appeal in the case of Ciban Management Corporation against Citco BVI Limited and Tortola Corporation Company Limited. This is a hearing of an appeal from the Court of Appeal of the East Caribbean Supreme Court in relation to a commercial dispute concerning a company in the British Virgin Islands. The appeal is brought by a British Virgin Island company, Ciban Management Corporation, against an order of the Court of Appeal dismissing its appeal from a judgment of Acting Justice Bannister, which in turn dismissed Ciban's claim. Today, the appellant is represented by Mr. Ben Hubble, QC, and the respondents are represented by Mr. Stephen Thompson, QC. We will have a short adjournment of 5 minutes at 11:45 a.m. or around then before resuming the hearing. I will introduce each of the justices who is sitting in this appeal and then invite Mr. Hubble to make his submissions. I am Lord Hodge and am presiding this morning. Lady Black.
Good morning.
Lady Arden.
Good morning.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
Thank you. Mr. Hubble, I now invite you to make your submissions.
My lords and ladies, thank you. I appear on behalf of the appellant, which for ease I propose to call Spectacular, and I act on the instructions of Pinsent Masons, and my learned friend Mr. Stephen Thompson QC appears for the first respondent, which for ease I will refer to as Citco BVI, and the second respondent, which I shall refer to as TCCL. Lord, the appellant appeals against the judgment of the Court of Appeal of the East Caribbean Supreme Court handed down on the 13th of February 2019. And the court will have seen Spectacular's grounds of appeal, which are to be found at page 2379, which identify 4 grounds of appeal for consideration by the Privy Council, which in short order I summarise as first, the question of what duties were owed by each of TCCL as director and by Citco BVI as registered agent or de facto director. Second, the question of whether the respondents were entitled to act on the requests of Mr. Costa in respect of the 5th power of attorney and the associated documents. And this engages, among other things, a question as to what, if any, was the ostensible authority of Mr. Costa and on behalf of whom. Third, the question of whether the respondents ought, in any event, to have been placed on alert by what Spectacular contends were certain red flags in relation to the 5th power of attorney in August 2001 and associated documentation that was requested and generated in November of 2001. And fourth, the question of whether the respondents were obliged but failed to ensure compliance with Section 80 of the International Business Companies Act 1984, which I shall refer to as the IBC. In addition, there is a 5th issue raised by the respondents by way of counter notice, namely whether the respondents or either of them are entitled to an indemnity from Spectacular pursuant to Article 26 of its Articles of Association and Section 57(1) of the IBC. Although the point was argued both at first instance and in the Court of Appeal below, that counterclaim has not been the subject of a judicial determination in this case, in light of the findings that there was no breach of duty by either respondent.
Yes, I wonder if I could add at this point that the board has had an opportunity to discuss the question of the indemnity, and is of the view that we should not determine that without having the assistance of the local courts on that matter, they having not ruled on it. Accordingly, if your appeal were to succeed, Mr. Hubble, we think that that is a matter that should be remitted back to the BVI courts along with the other matters which would have to be considered in any event. The other point I would wish to make to you is that it is the practice of the board not to review findings of fact of a trial judge which have been upheld by the Court of Appeal, and there is considerable authority to that effect. So I invite you to bear that in mind when you make your submissions. Thank you.
I'm very grateful. Thank you, my Lord. The approach that I propose to take, my Lord, is to take the court to certain of the key underlying documents that set out the material events from 1997 to 2001, to take the court through certain key elements of the judgments at first instance and on appeal, and then to set out spectacular submissions in relation to the four matters now that I have identified above, but not now in relation to Article 26.
Thank you.
My Lord, Spectacular was incorporated in the BVI on the 21st of March of 1996. And if I can invite the court's attention to page 2297. The court will there find the Memorandum of Association of Spectacular, and we'll see there from, in particular, clause 3, that the company's registered agent from incorporation on 21st of March 1996 was Citco BVI, and that the object and purpose of the company was to engage in any act or activity that is not prohibited under any law for the time being in force of the British Virgin Islands. And then if my Lord was to go down to clause 10 on the following page, 2298, one will see that the shares in the company made by resolution of the directors be issued in registered or bearer form or in combination of both. And if one then was to go on to page 2300 and to the Articles of Association, one finds there at Article 6 at the footer page 2300 that the bearer of a bearer share certificate shall be deemed to be a member of the company and should be entitled to exercise the rights and privileges of that company. And over the page at Article 7, that the bearer shall produce the same in order to exercise his rights as a member of the company. And then in Article 8, there is a process for authentication for the bearer's signature to any written resolution which is identified as the relevant document. And at Article 10 on page 2302, the bearer of the bearer share certificate shall for all purposes be deemed to be the owner of the shares comprised in such certificate, and the directors are under no duty of inquiry in relation to who the member is who holds those bearer certificates. My Lord will appreciate that as from when we come on to it in the story, as from the 27th of October 1997, Mr. Stallman, Mr. Byington's lawyer in Florida, held 5 bearer share certificates in custody for Mr. Byington. If I then turn from the documents dealing with incorporation of Spectacular to the participants in the story, in circumstances that I'll come to in more detail a little later, The second respondent, TCCL, was appointed as sole director of Spectacular on the 27th of October 1997 by Citco BVI. And TCCL's directors were employees of Citco BVI, and at the material time in 2001, those relevant individuals were a Mr. Kellogg and a Mr. Smith. Mr. Byington was from the 27th of October 1997 onwards the ultimate beneficial owner, or UBO, of Spectacular. And from 1998 onwards, Spectacular owned a large industrial premises in Sao Paulo, Brazil, which comprised 5 separate parcels of property, and I shall refer to that as the property. Mark Stallman of Stallman & Stallman was a US attorney based in Florida, who was instructed on behalf of Mr. Byington in October 1997 to obtain a BVI company in the event Spectacular for the purposes of holding the property. And Mr. Stallman held 5 bearer share certificates in respect of Spectacular on Mr. Byington's behalf. And Mr. Stallman was identified by Citco BVI in their files as the correspondent for Spectacular. And Mr. Byington was identified in those files as the UBO. Mr. Enrique de Moura Costa, or Mr. Costa, was an associate of Mr. Byington, who, among other things, from 1999 had acted as manager of a company of Mr. Byington's in Paraguay, Guías Latinas, which held the concession for the Yellow Pages there. And Mr. Costa initially passed on Mr. Byington's behalf instructions to Mr. Stallman in October 1997 in relation to the acquisition of Spectacular, and also occasional requests thereafter to Citco New York, which I'll refer to as Citco NY, and subsequently Citco BVI in the period to January 2000. And the consequences in law of the status and role of Mr. Costa were a key matter in dispute at the trial of liability in late 2012. If I turn then to the documents from the time when Mr. Byington became the UBO of Spectacular in October 1997, if I can invite the Council's attention, please, to page 1276. My Lord will see there a fax from Mr. Costa, and sees his signature at the foot of the page, to Citco NY. Mr. Eric Van Alst is a representative of Citco NY, not Citco BVI, instructing Citco NY to proceed with the necessary measures for what is referred to there as the incorporation of Spectacular. It identified that Citco was to be appointed as a director. 5,000 bearer shares were to be issued through 5 certificates and to be sent to Stallman & Stallman in Florida. The purpose of the company was to engage in any act or activity not prohibited under law in BVI. The beneficial owner was to be Mr. Byington, and the text of a power of attorney was attached and said to be immediately required. If we then go on to page 1277, there was a fax then from Citco New York NY to Citco BVI, identifying under the heading Citco Corporate Services Inc. New York, about a third of the way down the page, that Mr. Stallman was to be the correspondent. And this is the only formal record in the respondents' files of who was to be dealt with and authorised on behalf of Mr. Byington as UBO. Mr. Stallman was identified as having the bearer shares in custody from Mr. Byington, and the purpose of Spectacular was identified. One sees under comments 4 dashes down. The purpose the spectacular was identified as real estate holding. There is reference to a preparation of a management agreement between Mr. Byington and Citco BVI and TCCL. In the event no management agreement was ever signed, there are drafts of the management agreement at pages 2310 and 2313. Those management agreements, had they been signed, would have been between Mr. Byington and Citco BVI and TCCL. Mr. Byington's evidence had been that he did not sign the management agreement because he did not agree with the indemnity that the management agreement provided at clause 1.1 to TCCL as director. The judge's finding was that Mr. Byington refused to sign the management agreement because he did not want anyone to find out that he owned Spectacular. In my submission, and conscious of my Lord Hodge's observation at commencement of this hearing, the reason that Mr. Byington did not sign the management agreement is not of central importance. The important point is that no such management agreement was ever entered into, and there was so the position is that there was no written contract ever entered into between Mr. Byington and the respondents, and indeed there was never any invoice rendered by either respondent to Mr. Byington. The invoices are all addressed to Spectacular. As referred to in the earlier faxes, and one sees at page 1274, there was a first power of attorney that was issued on the 27th of October 1997, which was for the purpose of legal proceedings against Graviasos Electricas SA, which I shall refer to as GEL. And the grantee was also authorised to represent the grantor, that is Spectacular, before any agencies, authorities or courts in Brazil. And this was a power of attorney provided to a lawyer, Mr. Valente. One sees that about 5 lines down in the power of attorney. The following day, on the 28th of October, and one sees this at 1292, my Lord will see a invoice. It's a little indistinct at the top, but it's issued by Citco, and it's addressed to Spectacular Holdings, and one sees that it is for includes domiciliary services and provision of a registered office and registered agent. It includes, if one looks 4 entries down, directors' fees for the remainder of 1997 of $125, and directors' fees for 1998 on account of $500. On the face of this invoice, there's no identification there that those are being rendered on behalf of TCCL. This is an invoice from Citco BVI. If one then went on to page 1290, one sees another fax from Mr. Costa to Citco NY, confirming that Mr. Byington, one sees in the first sentence, is the beneficial owner, and Mr. Costa confirms that a reference letter will be provided by Mr. Stallman, and finally Mr. Costa chases for the power of attorney. Then if one goes to 1296, one sees a fax from Citco NY to Mr. Costa at GEL, and at this stage the corporate documents and the power of attorney, once legalised, were to be sent to Mr. Stallman as correspondent, although we see from this fax that the power of attorney itself is being sent direct to Mr. Costa. On the 1st of November 1997 at 1299, there is what is referred to as a blocking certificate issued by Mr. Stallman, or signed by Mr. Stallman. Sorry, I should say to be, yes, signed by Mr. Stallman, identifying that he holds the 5 bearer shares and that he holds those on behalf of Mr. Byington. Then, if my lord was to go on to page 1308, one sees what is called a KYCP checklist, and this identifies that and we see this, the name feeder is identified as Mr. Mark Stallman. One sees that about a quarter of the way down the page. And one sees that the activities of the company under the heading registered office only are identified as real estate. And if one scrolls down and goes over the page to page 1309, we see here the information of the beneficial owner, and there is identified Mr. Byington with an address in Brazil. And finally, if one goes down to page 2318, sorry, or 1310, depending on which, apologies, which section of the bundle my lord is in. It's page 1310, I think, on the previous reference I provided. One should find a heading information on the company and part D activities. And under that, the activities of the company indicate all activities in which the company be engaged in, and it's identified as holding. And then a little further down, there are choices to be identified, and one sees real estate, yes. So the no has been identified, so thereby identifying that the activity of the company is holding real estate. And I observe that there is nothing in this KYC checklist which either mentions Mr. Costa or identifies Mr. Costa as having any status or authority, whether on behalf of the company or Mr. Byington. If we go on to page 1318, one sees that Mr. Stallman faxes Citco New York. He is continuing to deal with drafts of the management agreement, and he provides as the final sentence there, please also remember to send a copy of the latest invoice to Enrique, that being a reference to Mr. Costa. We then move on in the story from November 1997 to April and May of 1998. And if my lord was to turn to page 1332, one sees an internal email exchange between Citco NY, that's Mr. Eric Van Alst, and Citco BVI, and there is reference there that 2 days ago we have sent you a request for a POA, a power of attorney, for the above company. The client called me today to let me know there was a mistake in the document. And if one goes on to the following page, one sees a fax of the 30th of April 1997, again from Mr. Costa to Eric Van Alst, in which he has provided the text of a further power of attorney. And I would submit that the clear inference from that email and this fax is that the client there referred to is Mr. Costa. He's being referred to as the client in the internal email within Citco, BVI, and New York. This gives rise to a further power of attorney, which, if one scrolls down, one sees that at page 1334, that Mr. Costa faxes, again, still Citco, New York, providing that correspondence in relation to a number of companies. One sees in the second sentence, it's kindly requested that from now on all the correspondence relating to Spectacular Holdings, Waterloo Capital, Xenex Capital, and Polar Sky Corporation be sent to Mr. Costa at the property. And I observe that this instruction, of course, did not come from Mr. Stolman or Mr. Byington, from Mr. Costa himself. And of course, Citco, BVI, and TCCL had no way of knowing that the property there referred to as the property that we are now concerned with, or the property was owned by Spectacular, or what, if any, relationship Mr. Costa had with either Spectacular or Mr. Byington. And on the face of the files, at least, I would submit that Citco NY and Citco BVI had no business complying with that request from Mr. Costa, because on the face of it, he had not been identified whether by the company or Mr. Byington as having authority to act on behalf of them. Nevertheless, Citco BVI did comply, and one sees at page 1335 and then 1336 that the second power of attorney is sent to be sent to Mr. Costa at the property, and at thus at page 1336 we see the first communication direct on the documents between Citco BVI and Mr. Costa, in which a copy of the second power of attorney is faxed to Mr. Costa. And that power of attorney is to be seen at page 1337. And it is to similar effect to the first power of attorney, but on this occasion it is addressed to a Mr. Delolo, a lawyer in Brazil, and without the specific reference to litigation against GEL. So that is the second power of attorney in April of 1998. If my lord was then to turn to 1352, there is a fax from Mr. Costa to Citco BVI instructing that all correspondence, reiterating his instruction that all correspondence relating to Spectacular and certain other companies should be sent to Mr. Costa at the property. And again, I observe that this is not an instruction from Mr. Byington or Mr. Stolman. Indeed, as the learned judge found at first instance, Mr. Byington did not have any form of contact at all with the respondents in the period from 1997 through to December of 2001. Nevertheless, Citco BVI acted on that instruction from Mr. Costa. Moving on to October of 1998 and page 1355. Mr. Costa provides text for a further power of attorney, that's power of attorney 3, as previously, and one sees that power of attorney over the page at 1356. And as previously, it's to Mr. Delolo, and it is, as previously, to appear before certain bodies in Brazil. And if one looks just above what's in capitals and witness whereof Spectacular Holding Inc., so if one looks just above that, one sees a sentence has been added. The grantee is also authorised to open and operate a bank account for non-residents in Brazil, which is the additional feature one sees in relation to this power of attorney, although it did not appear that that was ever acted upon. If we then go on to page 1377, please, we see email communications from Mr. Costa addressed to Citco BVI and Mr. Kellogg, who was one of the directors of TCCL, and Mr. Costa is confirming the wire transfer to pay the invoices in relation to 6 companies, and one finds at the bottom that it includes Spectacular Holdings Inc. So one sees that as the bottom. And the first email to that effect is dated the 27th of January 2000, and the follow-up is dated the 25th of April 2000. And the email that Mr. Costa is corresponding from and is sending this emails from is identified there as enrique2@byneto.com.brazil. And this is from the files, the only email communication from Mr. Costa with Citco BVI prior to August 2001. So that takes the story to April of 2000. In November of 2000, Mr. Costa resigned from working for or with Mr. Byington, and we see a translation of that letter at page 1379. He says, "Dear Alberto, hereby formalise today my irrevocable resignation from this organisation effective immediately. Sure we may agree on the best way to deal with the financial aspects involved. I'm available up till December 2000 to transfer to whoever you may designate the subjects I'm taking care of." The background at this stage was that Mr. Byington had borrowed $85,000 from Mr. Costa earlier that year in February of 2000, and that money was to be repaid by the end of 2001 with instalments in the meantime. And this resulted during the period of May, June and July of 2001 in a series of emails in which Mr. Costa was chasing Mr. Byington for payment. We then turn to the events in August of 2001 that led up to the particularly significant fifth power of attorney. And for that purpose, if I can invite my Lord to page 2330. And this is an email dated the 14th of August 2001, timed at 13.43. It bears the date on it of the 15th of August 2001, but if one looks up in relation to the email header, one sees that it was sent on the 14th of August 2001. And here, Mr. Costa is emailing Citco BVI on a new personal email address. So if one looks at the email, one sees that it is now hmoracosta@uol.com.br, and he requests Citco BVI to provide a power of attorney, the fifth power of attorney, which is going to grant Mr. Delolo the power to sell the 5 parcels of land comprising the property. If my Lord goes to follow these emails through in sequence, if my Lord goes to 2336, my Lord will there see in the middle of the page an email dated 14th of August 2001, timed at 15.29, in which Costa BVI, by Mr. Kellogg, who, as I've said, was one of the directors of TCCL, replies to Mr. Costa, states that he will proceed with the execution and legislation of the taxed power of attorney without any questions being raised, chases for payment of the 31st of December 2000 invoice, and warns that Spectacular will be struck off if the annual license fee is not paid. Mr. Costa replies at 1634, asking for the invoice to be sent by fax to a new fax number. One sees that in the second line, fax number 551131688674. And one sees that is immediately followed by, at 2328, Costa, Citco BVI then faxed Mr. Costa at the new fax number with the invoice for the 31st of December 2000. And one sees that invoice at the following page, 2329, and it is in similar form to the one we had seen previously, in that it provides for domiciliary services and the provision of registered office and registered agent for the year ended 31st of December 2001, and directors' fees for the year ended 31st of December 2001 in the amount of $500, together with certain disbursements and the government license fee. On the following day, on the 15th of August, or dated the 15th of August, there is a director's resolution at 1427, page 1427 please, signed by Mr. Kevin Smith and Mr. Joseph Kellogg, as in the employees of Citco BVI as directors of TCCL, resolving to issue the power of attorney. And then at 2337, one sees the power of attorney itself, and it is to Mr. Delolo. It has specific powers to cause the sale and sell the property, which on the evidence was all the assets of Spectacular, without any limitation as to the identity of the purchaser, and without any limitation in relation to the price or the terms. And there's no evidence that any questions at all were asked by either respondent in relation to this power of attorney, or that they turned their minds to whether it was appropriate for it to be issued.
There's also no mention of where the proceeds of sale were to go, if there were any.
My lady, no. There are no limiting factors in relation to the purpose for which this attorney can be used, other than obviously it is for the sale of the property. In relation to the purchaser, price, the terms, the funds, that there is nothing provided for in the power of attorney. If my lord was to go to 2333, picking up the story in the emails, just a little way down from the top of that page, at 0942, so this is the following day on the 16th of August, Mr. Costa emails Mr. Kellogg saying, in relation to the outstanding invoice, the instruction has been given today that NatWest Oxford is going to transfer the amount of $1,464 odd. And at 2338, we then see that a few days later, in August of 2001, the invoice was paid by a transfer from NatWest Oxford, an account in the name of a Pedro Moira Costa. And the evidence was Mr. Costa's son. At 2332, we then see, moving on a few days to the 23rd of August 2001, that Mr. Costa emails Citco BVI stating that the office will be closed for 15 days and asking for the power of attorney to be sent direct to Mr. Delolo. But that concludes the run of material in relation to the power of attorney, but the position was picked up again in November of 2001, and for that purpose, can I please ask you to go to page 2342. I'm afraid this has come out with shading, so it's a little harder to read. But in picking up the email just down from the top of the page, Mr. Costa emails Citco BVI in relation to documents needed by the Brazilian notary in order for the sales deeds to be executed. And he states that to execute the sales deed, the Brazilian notary needs a certificate of good standing and resolutions of the sole director in relation to the issue of the fifth power of attorney. And if I just read over the wording, it says, we are still negotiating with the notary if a statement verifying that the company has no debt that will obstruct the sale of its assets, but the director's certificate confirming the same will be sufficient. The documents above are to be duly notarized and legalized by a Brazilian consulate. However, we can save much time if you fax me said documents duly signed, but before the Brazilian consulate. If we work our way up the email, The following day, towards the top of page 2341, Mr. Costa emails Citco BVI again, inviting them to please disregard item C below. That's the statement verifying the company has no debt that would obstruct the sale of its assets, which is no longer required. And he says what is actually required is the certificate of incumbency, which you mentioned before, which is a document generated by the registered agent identifying who the officers of the company are. Then at 1757, if we move up the email to page 2340 to thankfully a clearer page, Citco BVI by Miss Nixia Titley reply saying, please confirm if you want a certificate of incumbency or a certificate of good standing issued by the registry. Mr. Costa replies to that saying, I need both, and the resolutions of the sole director of Spectacular related to the issue of a power of attorney in favour of Ennio Louis de Lolo as well. And then finally, in this run of emails, if we move up to page 2339, the following day, on the 21st of November 2001, at 8:10 in the morning, Mr. Costa emails Citco BVI confirming that all the necessary documents are to be faxed to a new fax number, to the new fax number 551131688674, and then sent to a new address for Mr. Costa. One sees a new address there identified. So he chases for a certificate of incumbency, certificate of good standing, a resolution of the sole director in relation to the power of attorney, confirmation that TCCL is the sole director, and that Mr. Kellogg and Mr. Smith are authorised to sign, and finally the invoice. And one sees at page 1456 that the following day, the 22nd of November, that Citco BVI email Mr. Costa on this new fax number saying, as per your instructions, please find attached a copy of the certificate of good standing, certificate of incumbency, and the resolutions authorising the issuance of the power of attorney, all legalised with apostille. The originals will be sent to the consulate today. As these documents show, Citco BVI organised in November of 2011, at Mr. Costa's request, the necessary documents, in particular certificates of incumbency and obtaining the certificate of good standing and the resolution of TCCL in relation to the fifth power of attorney, which in turn were necessary to enable and facilitate the sale of the property, and those documents were then sent to Mr. Costa at his new address. To complete the story, a deed of sale was then entered into on the 14th of December 2001 before a notary in Brazil between Spectacular as the seller and a Mr. Law as purchaser for a sale of the property at 1.15 million Brazilian dollars. And for my Lord's note, there's an English translation at 2353, but I don't think we need to go to it. Spectacular contends that that was a sale at a significant undervalue. In the event, some half the purchase price, some 575,000 Brazilian dollars, was paid on execution of the deed, with Mr. Costa taking 316,759 Brazilian dollars thereof as payment of monies that he contended were due to him from Mr. Byington. And as the judge found at trial, Mr. Byington was entirely unaware of the above, or the intended sale of the property, until he was informed of the same by Mr. Costa on the 14th of December 2001. And one sees at page 2343 forgive me. Apologies, I put the wrong number in. That Mr. Byington emailed Mr. Costa on the 14th of December 2001, having been informed about the sale. Enrique, you must be joking, and it's a very bad joke. See how you can undo this, because even a child can see this is a phenomenal loss. When did you say it would be sold? The wages are paid up front from what I know, and by the end of December, everything indicates that you, with great sacrifice for me, will receive yours from another source, which is not this craziness that you are talking about. So that was the response of Mr. Byington on the 14th of December 2001. And Mr. Byington then set about attempting to unravel the sale, and as part of that, through his then lawyer, Mr. Green, he obtained what is referred to as a director's certificate, which is at page 2344, dated the 19th of December 2001, which confirmed that according to TCCL's files, and to the best of their knowledge and belief, Mr. Byington was the sole beneficial owner and the only person authorised to provide TCCL with instructions on behalf of the company. Spectacular to conclude the story, subsequently brought proceedings in Brazil against Mr. DeLollo, Mr. Law, the purchaser, and in due course Mr. Costa, to have the deed of sale set aside in what is referred to on the pleadings as the quiet title action, which action was finally settled in March 2008 on terms that Spectacular should pay $1.6 million to Mr. Law in exchange for the deed of sale being set aside. Accordingly, consequent upon the unauthorised sale of the property on the 14th of December 2001, Spectacular's case was, and is, that it suffered loss being the settlement sums paid to Mr. Law to secure the setting aside of the deed of sale, legal fees incurred in the quiet title action, and lost rent whilst the property's title was blighted during the quiet title action. Spectacular then issued proceedings against Citco, BVI and TCCL on the 14th of December 2007, and the matter came on for trial of liability before the Honourable Mr. Justice Bannister in November of 2012. If I then turn, if I may please, to the judgment of Mr. Justice Bannister, which one finds at page 2119. And if I highlight certain of the findings of fact made by the judge, and I'm mindful of my Lord Hodges' observation, and we certainly submit that our appeal does not involve appeal against findings of fact. Indeed, we submit that we proceed on the findings of fact made by the judge, but those findings of fact do not support the legal conclusions and findings which the judge made, and indeed likewise do not support the findings which the Court of Appeal made. If one turns, and I highlight certain of those matters, if one goes to page 2122, and to paragraph 12 of the judge's judgment, and identify certain of what I say are important findings that the judge actually made. But at paragraph 12, the judge identifies, in relation to the email exchanges on the 20th and 21st of November 2001, that Mr. Costa emailed Citco BVI and asked for further documents to be produced. It was made plain that they were required for the purposes of the proposed sale. The email asked that the documents be sent to Mr. Costa's home address rather than to the property. Citco BVI did not consult Mr. Byington about any of these transactions, nor did it inform him of them subsequently. At paragraph 19, the judge identified on page 2124, as was the case, that there was no evidence adduced on behalf of the respondents from anyone at Citco BVI or TCCL with actual knowledge of the events in question. Then picking up on a point I identified earlier, at paragraphs 29 and 30, the judge found in relation to the management agreement that Mr. Byington refused to sign it because he did not want anyone to find out that he owned Spectacular. And then at paragraph 45 of the judgment, the judge on page 2129 recorded as follows, that it's common ground that Mr. Byington had given his approval, either specifically or generally, for all the corporate acts carried out on Spectacular's behalf, down to and including the issue of the fourth power of attorney on the 2nd of September 1999. There is, however, no documented evidence to suggest that Mr. Byington told any of the professionals with whom Mr. Costa dealt on his behalf that they could safely rely upon his instructions. Mr. Stallman clearly treated Mr. Costa as having the authority to give instructions to Mr. Van Alst at Citco, New York in October 1997. And Mr. Van Alst treated Mr. Costa as having authority to give him instructions on behalf of Mr. Byington right down to October 1998. Citco BVI, for its part, was comfortable receiving instructions ultimately from Mr. Van Alst in relation to Spectacular matters down to October 1998 and to accept them directly from Mr. Costa thereafter. So far as the available documents go, none of these professionals ever asked Mr. Byington for confirmation of any of these instructions. Now, it's right to identify that the judge at paragraph 50, which starts at page 2130 and then on to page 2131, identified at the top of page 2131 on the facts as found, paragraphs 2 to 45, Mr. Byington had so arranged matters that those engaged on his behalf on the affairs of Spectacular were expected to act on the instructions of Mr. Costa. And he goes on to say that Mr. Byington, at the conclusion of page 50, that Mr. Byington did not go down the route of executing the management agreement, but must be taken to have accepted the risk that Mr. Costa might one day betray him. And to similar effect at paragraph 51 that Mr. Byington set up a system on which he expected others to rely, under which he remained in the shadows whilst Mr. Costa communicated instructions and was the point of contact. And to pick up on my Lord Hodges' observation, I don't seek to overturn that finding of fact, but I do and will submit in due course that in relation to the question of ostensible authority, which I say is directly relevant to whether these respondents were entitled to rely on the instructions and requests from Mr. Costa, that the findings of fact and indeed the underlying evidence, but the findings of fact don't evidence that there was a representation by Mr. Byington, including by conduct or any course of dealing, such as could amount to a representation for the purposes of ostensible authority. Essentially, because Mr. Costa just took it in the eyes of the respondents, Mr. Costa just took it upon himself to start corresponding with them and directing that materials and correspondence be passed to him, and that does not of itself evidence a course of dealing which can be ascribed to a representation made by Mr. Byington to the respondents. So I do, my lord, take issue and submit with the conclusion that the respondents were entitled to rely on the instructions, but I don't take issue with the findings of fact made by the judge.
Was there ever a point in time when Citco had a direct communication with Mr. Byington?
My lady, no. The direct communications at the outset were from Mr. Stolman and then from Mr. Costa, as we've seen, although initially that correspondence was with Citco New York, and then it was Citco New York that passed on instructions to Citco BVI. And then as we saw in the course of the correspondence, including from 1998 onwards, there starts to be communication then direct between Citco BVI and Mr. Costa. And Mr. Costa directs that correspondence should be sent to him at the property. But there is no direct communication between Mr. Byington and either Citco New York or Citco BVI.
Thank you.
Can I just ask you this? Signed by Mr. Byington personally, which was in relation to the payment of some fees for one of the powers of attorney.
There were checks from a number of different sources that paid the fees, and one of them, I believe, was a check from Ciban. At that stage, Ciban had no direct relationship with Spectacular, but the signature on that was from Mr. Byington.
Yeah. Thank you.
But my lady, anticipating my submission on that, my submission on that, so far as ostensible authority is concerned, is that the requests from Mr. Costa were met without more, and documents were sent out, such as the power of attorney, but there was nothing that came back in any formal sense to Citco BVI or TCCL that showed that those documents were then being used by Mr. Byington or with the approval of Mr. Byington. That, this is not like the situation where the agent of the principal agrees that there are some goods going to be provided and the goods are provided and so forth. Nor is this like the situation of Mr. Masters, the head of the employment division in Kelly and Fraser. Mr. Costa is just an individual on the face of the documents, is just an individual who writes faxes without being attributed to any particular position held for or on behalf of Mr. Byington. And indeed, in August of 2001, is just a new email address, which is the work of a moment to generate a new personal email address. If I can go to page 2134 and paragraph, pick up certain findings by the judge in paragraph 60 and through to 63. The judge found that there was no doubt that in paragraph 60 on page 2134, as a director of Spectacular, TCL was subject to all BVI legislation, whether that legislation relating to companies or not, and was bound to comply with it and to act honestly and in good faith. The exceptional question in relation to section 80 of the IBC, which I'll come on to later, nobody suggests that it did otherwise. But to attribute to TCCL the sort of duties which affect directors charged with responsibility for the overall management of the affairs of the company, members expect the board to bring to the table their own skill and to manage its affairs by applying those skills independently, or day-to-day intervention and participation on the part of the members is unrealistic. And the judge went on to find in paragraph 52, about 10 lines down on page 2134, that provided that Mr. Byington's instructions did not involve dishonesty or illegality, therefore, TCCL could safely act upon them without more. And he went on to identify that its role was execution only. One sees that at the top of page 2135. And Mr. Byington would have been appalled had TCCL set about challenging the commercial wisdom of any of the instructions which it received. And then at paragraph 63, he found that in this case TCCL was intended to be nothing more than the instrument through which Mr. Byington's will in relation to Spectacular could be given legal effect. And as he was entitled to do, Spectacular's beneficial owner qualified the duties to the point where they were almost invisible. Its responsibilities were limited to ensuring that Spectacular's acts were valid and lawful.
Mr. Hubble, I wonder if you could keep your voice out. I mean, this is being broadcast as well to people who don't see the document. So while I appreciate you have to read the document, if you can make sure your voice is carrying to the microphone.
Of course, my lord, thank you. I'll read that again. In paragraph 63, the judge found and identified, as he was entitled to do, Spectacular's beneficial owner qualified the duties owed to Spectacular by TCCL to the point where they became almost invisible. Its responsibilities were limited to ensuring that Spectacular's acts were valid and lawful. And at paragraph 64, the judge concluded that that was a perfectly lawful arrangement, but the company itself has no separate right in these circumstances to claim that the board owed it separate standalone duties. Indeed, if this sort of relaxation on the part of ultimate beneficial owners of the duties which would otherwise be owed by directors to the companies which they own were not permissible, the provision by fiduciary services providers of companies like Spectacular and directors like TCCL for the purposes for which they are provided, at the rates for which they are provided, would have to stop. So I identify that in my submission that the judge went on to identify two matters which I say are matters of law based on the findings of fact that he made, which I respectfully submit were wrong. But the first is that Mr. Costa had the authority, perhaps I should put it the other way around, based on the way the judge approached it. The way the judge approached it was that the respondents were entitled to rely on the instructions of Mr. Costa. He did not think that the question of authority or ostensible authority was relevant, but he concluded that the respondents were entitled to rely on the instructions of Mr. Costa as being the instructions of Mr. Byington, and secondly, that in those circumstances, the effect of that was that the only obligation on behalf of the respondents, and in particular TCCL as director, was to act on those instructions, and there was no separate duty owed by the director to the company. And so the court has my submission in relation to that. I submit in relation to the first of those that on the material, and indeed on the judge's findings, Mr. Costa did not have the ostensible authority of Mr. Byington, because there wasn't a course of dealing such as could amount to a representation by Mr. Byington. And in any event, as I'll come on to, in any event, the facts of the requests in August 2011 and November 2011 were such as should plainly have put the respondents on inquiry as to whether indeed Mr. Costa did have the relevant authority. And there's no indication that that the respondents went through any process such as that, or indeed that they actually relied on Mr. Costa as being the agent of Mr. Byington. There's simply nothing on the files or in the evidence that addresses that. And secondly, I say that the geomatic principle, which is it being effectively referred to here, or as my learned friend refers to it, the multinational gas point, does not apply in these circumstances, particularly when Mr. Byington is an ostensible agent at best, and that his instructions amount to a fraud on the company. There was a separate aspect of Spectacular's claim in relation to section 80 of the IBC, which is set out on page 2136 of the judge's judgment.
Just before you go to that, when you say there was a fraud on the, I think you said the creditors, how was that manifested precisely? I think you have to formulate that.
Well, my lady, the instruction provided by Mr. Costa was for a dishonest purpose, which was to enable a sale of the company at an undervalue. So Mr. Costa could recoup what he believed himself to be owed by Mr. Byington. So the requests were for the provision of the documentation, which in turn was going to be used to facilitate and enable the sale of the property. And that sale of the property was a fraud on the company because it was extracting its assets, we submit as an undervalue. And I submit that the geomatic principle.
Mr. Hubble, I think Lord Burrows would like to raise a question.
Yes, of course.
Yes, I'm correct in thinking, am I not, that in relation to the first 4 powers of attorney, I think I saw somewhere in the judgment common ground that they were actually authorised by Mr. Byington. Is that correct as you understand it?
That is correct, my lord.
Thank you.
The sequence, my lord, I say the relevant sequence arising out of that is was accepted as a matter of fact that Mr. Costa did have Mr. Byington's authority to provide the instructions which he did in relation to the first 4 powers of attorney. So in relation to those first 4 powers of attorney, Mr. Costa did have actual authority. However, the consequence upon the resignation in November of 2000 by Mr. Costa, he ceased. I'd say this is, although the judge didn't approach it in a matter of ostensible authority, but this is the consequence of the judge's findings, that Mr. Costa ceased to have the actual authority of Mr. Byington. And then the question is whether in those circumstances Mr. Costa had the ostensible authority, or whether the respondents were entitled to treat Mr. Costa as having that ostensible authority.
Vis-a-vis Citco and TCCL and the first 4 powers of attorney,
Yes.
their position is that they wouldn't know, as I understand it on your submission, whether there was any authority or not.
Exactly. Well, the ostensible authority is dealing with a situation, in my submission, in which the agent does not have authority. And the question is, has that individual been cloaked in some way with the authority of the principal? And that is not, that may be by way of an express representation, or it may be by way of a course of conduct. And my point in relation to ostensible authority is that on the face of Citco BVI's files, they ought not actually to have been dealing with the requests from Mr. Costa at all. As it happened, he did have the actual authority of Mr. Byington in relation to those four power of attorneys. But those 4 power of attorneys were simply, if I can put it this way, sent out into the ether by Citco BVI. They had no idea whether they were used or not used. They had no idea what purpose they were going to be put to, or whether they were ever put to a purpose. And so a course of dealing has to have an element of a two-way street, or an element of, as with Mr. Masters in Kelly and Fraser, someone who has a known position, company secretary on behalf of a company, or the head of the employment benefits division, and that carries with it the idea that they are then going to be able to communicate instructions on behalf of those who do have the power to make the decisions.
And what about the argument that might be made, perhaps, that if those 4 powers of attorney happen to have actual authority, they're then acted on by Citco and TCCL, and there's no problems with doing that over a course of time? Nobody raises any objections to that happening. Spectacular doesn't raise any objections.
Well, Spectacular doesn't raise any objections, but equally Citco BVI and TCCL have no idea what happens as a result of them. This isn't a more normal situation would be where that gives rise to a transaction and the directors are aware of the transaction. It gives rise to the sale of an asset or the acquiring of an asset, and that the company then knows that, that TCCL then knows that those powers of attorney have been used, but they know nothing. In my submission, they know that they receive a request from Mr. Costa and they send the power of attorney out. So I submit that rather than that being a course of dealing, it's actually just making a virtue of your past defaults. because on the files, none of that should have been happening. And Citco BVI had no way of knowing what that material was then used for.
Thank you.
My Lord, I'm conscious of the time. It'll be 2 minutes for me to deal with section 80.
Just before you do, I'm sorry, you said that there was a sale at an undervalue, but exactly what did Citco know about the proceeds of sale under the fifth power of attorney?
Well, my lady, they knew nothing about it.
There could have been £1 real.
Well, my Lord, my lady,
No real.
all they knew under the fifth power of attorney was that there was going to be, that it could be used for the sale on any terms of these 5 parcels of land. That's all that Citco BVI knew. They didn't know, Citco BVI and TCCL didn't know that separately. They didn't know that Spectacular owned those parcels of land. They didn't know that that those parcels of land were Spectacular's only property. It didn't know anything about the terms of the sale.
Just 2 quick points. The first is they would, of course, have had the accounts because they would have to have filed them, wouldn't they? The registration agents.
My lady, that is a...
You might want to think about that. But the second point is that the point about a course of dealing really falls away if the fifth power of attorney was on the terms you suggest.
Well, my lady, it's been referred to in the litigation as the red flags point, but I submit that as with the approach of the Privy Council in the East Asia Company case of last year, that in the circumstances of the power of attorney in August 2011 and the documents in November of 2011, the TCCL and Citco BVI should have been placed on inquiry as to whether Mr. Costa really could have had that authority, because the fifth power of attorney was effectively a blank check, because it would enable the recipient to, or Mr. Delolo, to then sell the property on any terms for any amount. So it's of a different character, but also we say that Citco BVI and TCCL didn't make it their business, as they should have done, to have known what the assets of the company were, and that this was a sale of all the assets of the company.
The earlier powers of attorney gave the Brazilian lawyer a wide power to litigate generally and to reach agreements with government and other agencies on behalf of the customer. The other powers weren't tied to a specific litigation or a particular purpose. They gave a wide range of power to the same Brazilian lawyer, did they not?
My lord, they did.
With the authority of Mr. Byington.
My lord, yes, but one has to look at, in my submission, all the circumstances together of what happened in August 2011, and in what happened in August 2011 in my submission is that an email lands from a new email address from someone saying that they're Mr. Costa, asking for a power of attorney, which transpires is going to be used to sell all the assets of the company. And
no, I mean, I have your point that there was a new email address. I have your point it was selling the properties, and I have your point that that precious little inquiry was made at all. But if we compare the powers of attorney, they were all worded in very general form, giving the Brazilian lawyer a lot of power to do things on behalf of the company without stipulating limits on what he could or could not do.
My lord, yes, but there is then the oddity from the director's point of view that those power of attorneys are just sent out. They don't know what they're going to actually be used for, if they're going to be relied upon at all, or whether they were ever relied upon.
Yes. Thank you.
I'm conscious of the time. Is that a convenient moment now to take a break? Or?
Yes, we'll break for 5 minutes now and resume at midday if that is appropriate. Thank you very much.
Thank you,
We resume the hearing, and Mr. Hubble continues his submissions. Thank you.
Thank you, my lord. I was dealing, or just turning to section 80 of the IBC as dealt with by the judge at first instance at page 2136 in the bundle, paragraph 66 onwards of his judgment. Section 80 of the IBC, as there identified, provides in relation to any sale of more than 50% of the assets of a company incorporated under this Act, if not made in the usual or regular course of business carried on by the company, shall be made as follows. And then there are two stipulations identified. The first is that the proposed sale or other disposition must be approved by the directors. And the second is that upon approval of the proposed sale, the directors must submit the proposal to the members for it to be authorised by a resolution of members. And strictly, that would be Mr. Stallman. Mr. Stallman was the member under the articles because he held the bearer shares. And so we can be clear that the nature of the case advanced by Spectacular was, and indeed is, that there was a tortious duty on TCCL as director to ensure compliance with applicable BVI legislation. And as part of that, they needed to know and understand what the assets of the company were, and know and understand what the transaction was that was being contemplated by the power of attorney. And that had they done that, they would and should have ascertained that the proposed transaction was for more than 50% of the assets of the company, thereby triggering an obligation to comply with Section 80, which would, by this route, have brought to the attention of Mr. Stallman or Mr. Byington that there was a proposal to dispose of the assets of the property. The judge found that the sale of the property was in fact in the usual or regular course of business of Spectacular, and further that TCCL had never been told what the assets held by Spectacular were, and so TCCL had no means of knowing that Spectacular even owned the property, let alone whether it accounted for more than 50% of the assets, which was another condition to Section 80 applying. And the submission of Spectacular then and now is that it is plain in my submission that a company whose purpose, as we saw from the KYC checklist in the original facts identifying the company, the purpose was real estate holding, and it is plainly not in the usual or regular course of business for a company that holds real estate to dispose of all of it. And particularly in circumstances where the consequence would then be that Spectacular has no assets at all. So firstly, the judge erred in that approach because it simply doesn't follow with common sense in my submission and what was described as being the express purpose of the company. And secondly, we say, rather as with the situation where the absence of due diligence in relation to Mr. Costa in the past is turned by the respondents into a defence in the form of a sensible authority, but the judge fell into error in saying, well, the director didn't even know what the assets of the company were or what proportion these properties were that were being sold of those assets, because it was the director's obligation to know. There are certainly irreducible obligations of directors, as we set out in our case, and they extend to knowing sufficient about the affairs of the company in order that you can discharge your obligations properly. One of those obligations was to ensure compliance with BVI legislation. So that's the position in relation to Section 80. If I turn on, if I may, to the judgment of the Court of Appeal, and conscious of the time, I'm going to take my Lord, please, to page 2108 and just to paragraphs 51 and 52 of the findings of the judgment of the Court of Appeal. The Court of Appeal found, picking up the story in paragraph 51, 4 lines up from the bottom, the judge's findings that Mr. Byington had no valid complaint that Citco BVI had been negligent in providing the 5th power of attorney to Mr. Costa in August 2010, given the system which Mr. Byington had set up and expected BVI to follow, cannot fairly be criticised. And then at paragraph 53, the court found, in addition, and as argued before this court, and as Citco BVI had asserted in its defence to Ciban's case on agency, there is a good basis upon which ostensible authority could have been properly utilised as a shield to Ciban's case. Mr. Byington had previously expressed and by his conduct authorised Mr. Costa to deal with all matters in relation to Citco BVI and TCCL. So the Court of Appeal approved the judge's findings and approach, but went further in identifying that there was what they regarded as an additional defence available to the respondents, namely that they were entitled to treat Mr. Costa as having the ostensible authority of Mr. Byington. And there we say that the Court of Appeal fell into error, and Mr. Byington had never previously expressed to the respondents that Mr. Costa had his authority to act. And as I've touched on, and I'll come on to in a moment, there was no course of prior conduct or dealing by Mr. Byington, or with Mr. Byington, which authorised Mr. Costa in the eyes of the respondents to act on all matters in relation to Spectacular. Rather, we submit the history was simply one of no diligence by the respondents in the past, and contrary to what was recorded in their files, namely that Mr. Stallman was the correspondent, they simply took up corresponding with Mr. Costa at his request. So against that review of the judgments, I'll turn, if I may, to what I submit are one of the two central questions. In my submission, the two central questions are, were the respondents entitled to rely on the instructions of Mr. Costa as being the instructions of Mr. Byington? And the second question is, and relatedly, is there some principle that emerges from the authority of Geomatic and the multinational gas authority, to the effect that the instructions of Mr. Costa are in effect to be treated as acts of the company, or such that the director is entitled to act on them without more. And if I turn to the first of those, which is the question of whether the respondents were entitled to rely on the instructions of Mr. Costa as being the instructions of Mr. Byington, I submit that the correct analysis is as follows. On the findings of fact at first instance, Mr. Costa did not have Mr. Byington's actual authority in 2001 at the time of the request for the fifth power of attorney, nor on the findings of fact at first instance was there any express representation by Mr. Byington to the respondents that Mr. Costa had his authority. There was no course of dealing or holding out by Mr. Byington as principal, such as gave Mr. Costa ostensible authority to issue instructions in 2001. The respondents failed to establish that they actually relied on any representation by Mr. Byington, if there was one, and further, acting reasonably, the respondents should have been placed on inquiry in the circumstances as to whether Mr. Costa had authority to issue the instructions which he did in August and November 2001. And let me, if I may, develop those submissions. The first is the question of whether there has been a representation by the principal, and for ostensible authority to apply, the respondents have to establish that they understood themselves, consequent upon some representation from Mr. Byington, to be dealing with Mr. Costa as Mr. Byington's agent. And in my submission, there was no evidence to that effect from the respondents at trial, and considerable evidence to the contrary. Mr. Costa was nowhere recorded on the respondent's file as the correspondent. We've seen the email of the 30th of April 1998 in which Mr. Van Alst of Citco, New York, referred to Mr. Costa in internal emails as the client. That was page 1332. There's no reference at any stage thereafter up to the sale of the property on the 14th of December 2001. So Mr. Costa dealing as Mr. Byington's agent, whether in Citco BVI's documents or even in the requests or letters that come in from Mr. Costa. And the evidence, such as it is more consistent with the respondents thinking they were dealing with Mr. Costa as principal and not turning their mind to the question of his status at all. As we've seen, every letter or request that comes in subsequently from Mr. Costa on his own account is not on any form of letterhead referable to Mr. Byington. Mr. Costa doesn't describe himself as Mr. Byington's agent or associate. There's simply no evidence at the time of a direct representation by Mr. Byington to the respondents that Mr. Costa had his authority. That then leads to the question of whether there was a course of dealing which could be said to amount to a representation by Mr. Byington. And this court may well be very familiar with the case of Kelly and Fraser, but we have that in the authorities bundle at 3209, and I wonder if I could direct you to page 3218 in the judgment of Lord Sumption, and paragraph 15, Lord Sumption said, "It is clear from the judgments in First Energy that the Court of Appeal regarded their approach in that case as being wholly consistent with the law stated by Lord Keith in Armagus Limited and Mundogus. In the Board's opinion, they were right to regard them as consistent. Lord Keith's speech remains the classic statement of the relevant legal principles. An agent cannot be said to have authority solely on the basis that he has held himself out as having it. It is, however, perfectly possible for the proper authorities of a company, or for that matter any other principal, to organise its affairs in such a way that subordinates who would not have authority to approve a transaction are nevertheless held out by those authorities as the persons who are to communicate to outsiders the fact that it has been approved by those who are authorised to approve it, or that some particular agent has been duly authorised to approve it. These are representations which, if made by someone held out by the company to make representations of that kind, may give rise to an estoppel. Every case calls for a careful examination of its particular facts." In my submission, applying the principle as summarised there by Lord Sumption in paragraph 15, there was no established prior course of dealing such as could amount to a holding out by Mr. Byington of Mr. Costa. As I've said, first of all, the respondents do not have recorded anywhere in their files that Mr. Costa was authorised to provide instructions on behalf of Mr. Byington. And on the face of their own files, Citco, BVI and TCCL ought not to have accepted Mr. Costa's instructions in the period prior to 2001 without checking with Mr. Byington as the UBO or Mr. Stolman as the correspondent. And second, the fact of the prior powers of attorney established only that the documents were being sent out to what, to the respondents, was an unknown property in Brazil. Nothing more was heard about them. And whilst, as a matter of fact, Mr. Costa had actual authority to pass on those instructions in relation to the prior power of attorneys, that is neither here nor there in the context of ostensible authority. Ostensible authority means that an agent has authority of the principal in the eyes of a third party, even when he does not. And the basis for the principle is estoppel, i.e. that there has been a representation. And here there was no subsequent confirmation coming back from Mr. Byington as principal that Mr. Costa's past instructions were approved, or that Mr. Costa had some ongoing role for Mr. Byington. And the respondents, particularly in circumstances where they are professional services providers, are not entitled, in my submission, to turn their own prior inactivity and defaults into some form of protection for them. Third, there was no holding out by Mr. Byington of Mr. Costa to the respondents, that there was no communication of any sort from Mr. Byington to these respondents to the effect that Mr. Costa had his authority either to provide or pass on instructions. And I submit that Mr. Costa is not like Mr. Masters from Kelly and Fraser, who was the head of the company's employee benefits division and was communicating in that capacity in relation to Mr. Fraser's pension. Nor is Mr. Costa like the company's secretary referred to by Lord Sumption in paragraph 13 of Kelly and Fraser.
Lord Leggett.
Hubble, you rightly say that it all depends on the facts and circumstances of the case, but isn't the critical finding in this case the one at paragraph 51 of the judgment that you say you don't challenge, which is that Mr. Byington consented to an arrangement. Indeed, he expressly, he deliberately established an arrangement under which Mr. Costa was entitled and expected to give instructions without Mr. Byington being mentioned or copied into the communications or consulted, because he wanted to remain, as it was put, in the shadows.
Well,
So he authorised this whole manner of dealing, actually, with actual authority.
Lord, but in my submission, in the context of ostensible authority, course of dealing has to mean a two-way street, so that the judge found that Mr. Byington set up that system, but the respondents, who are the ones who rely on the representation, did not establish anything or have any direct course of dealing with Mr. Byington, such that they knew that that's what Mr. Byington had done. So if one's dealing with...
Is that right, Mr. Hubble? Because they knew that Mr. Byington had refused to sign the management agreement. And one assumes that they knew why, or could guess.
Well, my lady, there wasn't evidence from anyone at the trial, from anyone from TCCL or Citco BVI who had been involved or gave evidence about why that particular aspect happened. My point is that a course of dealing has to be a two-way street. There has to be something that comes back from the principal as part of the course of dealing, so that the third party can say, yes, this is a system which that individual or that principal has approved. Now, as a matter of fact, I accept that Mr. Byington set up and approved that system when it was applied in relation to the first 4 powers of attorney. But so far as the respondents are concerned, they are just receiving requests from Mr. Costa and sending documents out in reliance on them. And there was no, on the face of it, no due diligence done in relation to those prior requests to establish whether Mr. Costa in fact was the agent of Mr. Byington or what the scope of any authority was. Yes, my lady, Lady Black.
But what we do know is that in relation to one of the powers of attorney, Mr. Byington would, to the knowledge of respondents, or some of them, have known of it and indeed satisfied the invoice in relation to it.
Well, my lady, if they went so far as to decipher the signatures on the cheque, they would have seen or might have deciphered that one of them was from Mr. Byington in relation to, as I recall, the cheque from Ciban.
And let's suppose that they did do. Would that alter your submission?
Well, my lady, in my submission, no, because in order for there to be a course of dealing and a representation that can be relied upon, there has to be some authorization to the knowledge of the third party that the agent has that continuing authority. And it would be, in my submission, it's an insufficient basis for that to think that or assume that an individual at Citco BVI might have gone through the file and might have looked at who signed the cheque.
But in theory, can acquiescence, when the principal knows what is happening, can acquiescence on its own be sufficient?
Well, in my submission, if that acquiescence is communicated to the third party, because it's a course of dealing as representation, or it's a course of conduct as representation. And in my submission, if you look at these files, I submit that there was a glaring lack of due diligence throughout the whole process, and it's the law would be taking a wrong turn to say that fiduciary service providers of this sort who don't undertake proper due diligence and know who they are dealing with, having done that for a number of years and just simply sent out documents when requested, are entitled to elevate that into a defence when that same individual makes a further request which turns out to be a fraud on the company.
Standing back from the facts of this particular case, is Lady Blacknott right that acquiescence in the sense of inaction from which assent can be inferred can be a form of representation?
Well, my lord, yes, if there is something that can justify the inference. But I come back to my point that if we just analyse what happened here.
Again, I deliberately said coming away from the facts of the case. I was looking at merely as a generality, but I have your point that you say that this is really a case of a complete absence of any diligence.
Yes, my lord, absolutely.
Sorry, can I just ask one more follow-up, Mr. Howell? Was it the case that Mr. Costa was arranging payment of, for example, the directors' fees, and that they could see that that was happening, and could infer that the owner of the company, if he was unhappy with Mr. Costa dealing with that sort of thing, would have realised that the payments were being made or arranged by someone he hadn't given authority to over the space of several years?
Well, certainly Mr. Costa dealt with the administration of the payment of the bills. That's certainly true, my lord. But I would say that is qualitatively a materially different thing from the ability to provide instructions for a power of attorney, such as the fifth power of attorney, which is going to enable or facilitate the sale of all of the company's assets. If I can turn, if I may, to the question of reliance, as was recently re-emphasised in East Asia Company Limited, and a case which I know is known to certainly very well known to Lady Arden on the panel, the Lord Kitchen's judgment, and we have that at page in the authorities bundle at page 3418. And if we were to turn on to paragraph 67 at 3435, it's there identified that PT Satria's case on this issue also fails for another reason, however. It did not establish that it relied on any such representation. Indeed, such evidence as there was pointed to the opposite conclusion. As has been mentioned, and so on, it deals with the position of Mr. Genos, who was the director. And I say that the reminder there that the third party has to prove detrimental reliance, it is apposite here, and it is necessary, or it was necessary, for the respondents to establish that they relied on a representation made. And it is not enough to establish only that they relied on something said by the agent. It has to be reliance on a representation that can be attributed to the principal. And here, the respondents simply failed to establish reliance, as there was no evidence of the same, and none was adduced. The respondents go so far in their case, paragraph 101, to suggest that it's laughable to say that the respondents did not rely upon a past course of dealing as a representation by Mr. Byington. They say it's obvious that Mr. Costa's previous involvement would give the respondents comfort that they could take instructions from him as instructions from Mr. Byington, and that is common sense. But there's no actual evidential basis for that submission. There was no evidence at trial that the relevant individuals at the respondents at the time were so induced, or that they dealt with Mr. Costa on the basis that he was Mr. Byington's agent, or rather whether the case was that they just accepted Mr. Costa's instructions without turning their mind to his status at all. And after all, if they had ever turned their mind to what Mr. Costa's status was, then one would expect to see something to such effect in the files, but there was nothing. What the documents show is a complete lack of basic due diligence procedures. And as I've said, this is another version in my submission of making a virtue of their past defaults and lack of basic due diligence. On the basis of their files, they had no idea who Mr. Costa was or where he fitted into matters. All we know from the files is that they blindly followed his instructions. And so there is an obligation on a third party to say that they actually acted and relied on the representation, namely that they were dealing with Mr. Costa on behalf of the UBO, and there simply was and is no evidence to that effect. And finally, in relation to the question of ostensible authority, I say that the respondents should have been placed on inquiry in any event in the circumstances that prevailed in August and November of 2001, and the test to be applied as to whether the respondents failed to make the inquiries that a reasonable person, the test to be applied is whether the respondents failed to make the inquiries that a reasonable person would have made in all the circumstances in order to verify that the agent had that authority. And that issue was addressed expressly in the East Asia Company case and the judgment of Lord Kitchen, which reviewed the previous judgment of Lord Neuberger in the Akai case. And if I can take my lords and ladies to page 3441 and to paragraph 87, Lord Kitchen says, the present case is very different, however. The EACL does not contend it entered into a binding agreement with PT Satra. To the contrary, it is PT Satra that advances that contention. It says that a series of facts and matters justify the conclusion that EACL held Mr. Genos out as its properly authorised agent to enter the HOA on its behalf. And it is the opinion of the board that to ask in this context how those facts and matters would reasonably be understood and whether PT Satria reasonably relied upon them seems entirely appropriate. On a more general level, it's also important to keep in mind that the issue of whether two parties intended to contract, and if they did, the terms of that contract is to be determined objectively and from the perspective of the reasonable person. The relevant reasonable person is one who has all the background knowledge and who would reasonably have been available to the part, all the background knowledge which would reasonably have been available to the parties in the situation which they were at the time of the contract. And then a little further on page 3442, paragraphs 92 and 93, it's there set out that the board finds itself in respectful disagreement with the analysis that had been previously proposed by Lord Neuberger. As Lord Simmons explained in Morris and Canson, both the indoor management rule and the doctrine of ostensible authority allow the smooth operation of business by protecting those who are entitled to assume that the person with whom they are dealing has the authority which he claims. But this general principle cannot be invoked if he who would invoke it is put upon inquiry. He cannot presume in his favour that things are rightly done if the inquiry that he ought to make would tell him that they were wrongly done. And then finally in paragraph 93, the board therefore concludes that PT Satra could not rely upon the apparent authority of Mr. Genos to enter into the heads of term on behalf of EACL if it failed to make the inquiries that a reasonable person would have made in all the circumstances in order to verify that he had that authority. So the test is not one of good faith or sort of, it's not a subjective test. The test is whether the inquiries that a reasonable person would have made in all the circumstances in order to verify that he had that authority. And I submit, even if the board is against me on the question of course of dealing and representation, that respondents should plainly have been on notice that Mr. Costa did or might not have authority to provide the instructions, which he did in August and November 2001. And there were individually and collectively a number of very unusual features of the request from Mr. Costa in August 2001 and November 2001, which should have placed any competent registered agent or director on alert, but all was not as it appeared. And I highlight, and drawing on the documentation that I've shown the board already, the request from Mr. Costa in August 2001 was simply received out of the blue. Previous power of attorney had been issued some 2 years previously in September of 1999. And the last previous communication from Mr. Costa was in April of 2000. The request in August 2001 came from Mr. Costa on a new personal email, which was not confirmed from Mr. Byington or Mr. Stallman, and which was replied to without undertaking any due diligence at all. There was a new personal telephone number. There was a new personal fax number. Mr. Costa asserted that the office in Brazil would be closed for 15 days, and so documents should be sent elsewhere. The outstanding invoice from Citco BVI to Spectacular was faxed direct to Mr. Costa on his personal fax number. And on the 23rd of August 2001, that invoice was paid by a transfer from Mr. Costa's son's bank account in Oxford. On top of all of that, the sale of all of the companies.
Mr. Hubble, Lord Legate wishes to ask a question.
But weren't these all matters for the judge to evaluate, which he did at paragraphs 52 and 53, and he wasn't satisfied that the inference you're seeking to make was justified. In fact, he didn't draw that inference, and that was upheld by the Court of Appeal. So is it open to us now to start redoing it from the ground up?
Well, my lord, the judge did not deal. He did deal with the red flags, but he did not deal with them in the context of whether the respondent should have been placed on inquiry as to whether Mr. Costa had the ostensible authority of Mr. Byington, because the judge at first instance concluded that ostensible authority wasn't a relevant consideration for him.
Was that because he saw it as being confined to questions of contract, do you think?
Well, I think
negligence, I think, wasn't it?
Well, yeah.
Contract wasn't time barred for contract.
Yes, it was because he a different type of contract. If one looks at, I think it's paragraph 58 of his judgment at page 2133. I think the judge took the conclusion that the judge's view was that ostensible authority was only applicable in circumstances where Citco, BVI or TCCL were attempting to assert that Mr. Byington was bound by a contract.
That was my understanding of what he thought.
Yes.
But would the point not be the same? What I wish to know, I mean, are you saying that looking at these factors, the judge was plainly wrong? Or are you saying that we can infer in his treatment of the matter that the judge made some other error in law? And if so, what was it?
Well, the error of law is that ostensible authority was applicable, because it was that was going to determine whether or not the respondents as third parties were entitled to rely on the requests and instructions coming from Mr. Byington, and the judge didn't ask himself the question of whether, in the context of ostensible authority, they should have been placed on inquiry. And the judge also approached matters on the basis that the duties owed by TCCL were such that they were simply execution only, and they had been pared down to the point of virtually of invisibility. So the judge's starting point was that the directors weren't required to know what the assets of the company were, and the director wasn't required to know what the nature of the transaction was and what the terms of the transaction were. So I do say that the judge approached the red flags on a false premise as a matter of law, because he approached it on the premise that the directors had no business or were not obliged to know anything about the affairs of the company, and owed no duties in relation to matters other than simply, so it seems, to act on the instructions of Mr. Costa.
So, just to be clear, you are, as I understand it, accepting that the first instance judge was incorrect to rule out ostensible authority. That is, to that extent you accept the Court of Appeal's view that there was an issue of ostensible authority, but you're then saying that therefore the approach of the judge to the so-called red flags can't be read across to an issue that he himself didn't deal with, which was whether in effect there was reasonable reliance on the ostensible authority. Is that effectively what you're saying?
That is what I'm saying, my lord, but I am also saying that the judge approached the question of red flags in the context which he looked at them, which was a sort of general negligence context of whether there had been negligence by the director or the registered agent, on a false premise, because his false premise was that a director of a company of this sort has no obligation to understand anything about the affairs of the company. And so the judge approached it on the basis that there was no requirement for the respondents to know what properties the company held. There was no requirement for the respondents to know what the purpose of the transaction was, or what even the most basic terms of the transaction were. And my submission is that turns matters on their head, because even in relation to what one might describe as a paper director, there are certain irreducible obligations, and there are irreducible obligations to know sufficient about the affairs of the company so that you can discharge your responsibilities, including to ensure compliance with prevailing BVI legislation, and obligations to ensure that you're acting on authorised instructions, and to take basic steps to protect the assets of the company. And because the judge took the view that none of those duties applied, he approached the question of red flags on a false premise. If you approach it, as I say, one should, on the basis that the director needs to understand the basic affairs of the company, then what was happening in August and November should plainly have set off alarm bells. So I say simply that approached on that basis, that there were indeed a number of unusual and alarming features that should have prompted what should have been a fairly straightforward and simple task of checking either with Mr. Stallman as the correspondent and the holder of the bearer shares, or Mr. Byington if the reliance was on a representation and Mr. Costa was acting as agent for Mr. Byington.
Mr. Hubble, it's true to say, isn't it, that the judge only deals with the red flags under the heading of Citco and not separately in relation to the director? Is that not right? If I'm wrong.
Yes, he deals with the red flags in paragraph 52 under the heading of Citco BVI. But he then goes on to deal. He approaches, and this is the next substantive point I'm going to come on to. When he looks at the director's duties, he looks at those very much on the basis that they have been qualified to the point of extinction.
So he doesn't raise the red flag problem. Why are they nonetheless put on inquiry in the context of just GCCL?
My lady, yes, I perhaps you'll permit me to double check the judgment over the course of the short.
I may be wrong,
but he certainly deals with them in the context of Citco BVI at paragraph 52 of his judgment. But that perhaps reinforces the point that I was perhaps not making as fully as I should have done, which is that the judge simply said that TCCL had no relevant duty, and I submit that even in a director such as this one, who isn't going to be kept very busy in relation to the affairs of the company, but as I say, there are certainly reducible duties, and that duty extends to knowing the assets of the company and the affairs of the company, so that they can discharge their duties responsibly. And it was on that basis that the judge really came to the conclusion that the case on breach of duty just didn't get off the ground, if I can put it that way, in his view. And he takes the conclusion, as he says in paragraph 63 of his judgment, page 2135, its responsibilities were limiting to ensuring that Spectacular's acts were valid and lawful. And goes on to say that if it were to be different, then fiduciary service providers, companies couldn't provide the services they do at the rates they do. I mean, my lady, I of course say that if I'm stepping back from this and thinking about wider policy considerations, I would submit it's to the opposite effect, which is it's of no service to a jurisdiction that affords these sort of fiduciary service providers to countenance a situation in which the directors simply don't own the obligations that are provided for by statute, and there's no obligation to undertake due diligence, because that will actually have the effect that business people wouldn't want to invest their assets or undertake transactions via those jurisdictions if they know that they're not going to have any of the protections of statute or common law. So, as I say, my lady, in my submission, the judge just simply didn't approach the red flags on the correct basis because of the approach which he applied. And whilst in my submission, the Court of Appeal was correct to consider it as a matter of ostensible authority, they erred in adopting a similar approach towards the red flags and directors' duties, and that if you actually step back and think about the circumstances of this transaction, what happened in August and November 2001 should have put a director on notice that something was potentially awry. Can I And if I may, to the other point, which of course I rely on everything that I've said in the case, but I would like to take the opportunity to develop orally the question of the geomatic principle, because what underlay the approach of the judge and indeed the Court of Appeal was the principle that a shareholder of a solvent company can direct the board of a company to act in a way in which the shareholder so desires. Now, of course, if I'm right in my submissions that Mr. Costa did not in fact have the ostensible authority of Mr. Byington to provide the instructions, then in my submission you don't get on to the geomatic principle, or what my learned friend calls the multinational gas point, because in those circumstances the respondents just shouldn't have had any business dealing with the requests made by Mr. Costa in 2001. But the respondents in their case do seek to develop the geomatic principle and the line of reasoning, and they say that the appeal is simply about the ability of shareholders to bind their company, and as I say, that's what my learned friend describes as the multinational gas point. I submit that in fact the position is rather the other way around, and that the true position is that unless the respondents can establish they were entitled to rely on Mr. Costa's instructions as if they were tantamount to an act of the company itself, then the respondents' defence must fail, because otherwise they should have had no business acting on Mr. Costa's instructions. And in my submission, the geomatic principle, as with the multinational gas case, is concerned with express and informed consent from shareholders themselves, and it is also only concerned with instructions that are valid and bona fide. And in my submission, neither of those features are present here. It is a fact here that there was no express and informed consent from Mr. Byington as UBO or from Mr. Stallman as the member. And in my submission, the instructions from Mr. Costa were not valid and bona fide. Rather, they came from an individual who, as I explained this morning, was in fact affecting a fraud on the company. If I could invite the board's attention to the judgment of Mr. Justice Buckley in geomatic itself, we see that at page 2766. And in the case of geomatic, the liquidators sought repayment of sums paid to directors, E and H, as salaries on the ground that they were never voted for in a general meeting, as well as repayment of £4,000 paid to H as compensation for loss of office on the basis that it was unauthorised and not bona fide for the benefit of the company. And Mr. Justice Buckley held that where it could be shown that all the shareholders had assented to some matter which a general meeting of the company could carry into effect, that assent was as binding as a resolution in a general meeting. And if we go on, please, to page 2773, I invite the board's attention first of all to at the top of page 372, where Mr. Justice Buckley cites the case of Parker and Cooper. In Parker and Cooper Limited in Reading, the second case relied upon by Mr. McCulloch, the directors of the company had created a debenture and proceedings were commenced to establish that the debenture and the resolution which authorised its issue and the appointment of a certain receiver under it were invalid. Asprey J referred to In Re Express Engineering Works Limited and to In Re George Newman Limited, and himself expressed the view. Now, the view I take of both these decisions is that where the transaction is intra vires and honest, and especially if it is for the benefit of the company, cannot be upset if the assent of all the comparators is given to it. I do not think sorry, all the corporators is given to it. I do not think it matters in the least whether that assent is given at different times or simultaneously. And the judge then went on in a very well-known passage on the next page at 2774 at letters A and B. It seems to me that if it had occurred to Mr. Elvins and Mr. East at the time when they were considering the accounts to take the formal step of constituting themselves a general meeting of the company and passing a formal resolution approving the payment of directors' salaries, that it would have made the position of the directors who received their remuneration, Mr. Elvins and Mr. Handley, secure, and nobody could thereafter have disputed their right to retain their remuneration. And then at letter C, in other words, I proceed upon the basis that where it can be shown that all shareholders who have a right to attend and vote at a general meeting of the company assent to some matter which a general meeting of the company could carry into effect, that assent is as binding as a resolution in general meeting would be. But in my submission here, the instruction from Mr. Costa was neither honest nor bona fide, and it was certainly not for the benefit of the company. The instruction was part of a transaction which was in fact a fraud on the company. And in my submission, what emerges from the judgment of Mr. Justice Buckley is that the shareholders have to apply their minds to the issue. The principle is that if the shareholders assent, then that is as binding as if it was a resolution in a general meeting would be. But an instruction from an at best ostensible agent should not be treated in the same way, should not be treated as a shareholder having applied their minds to the very issue and having provided their actual consent. And an extension of the geomatic principle in that way would, in my submission, introduce uncertainty and a lack of protection for shareholders. And still more is that the case when the instruction, far from being bona fide, is itself a fraud on the company. My Lord, I was next going to go to the authority of both Holdings Limited, but I noticed the time and I wonder if that is convenient.
I think Lord Burrows would like to ask a question just before we break for the short adjournment.
Thank you. Can I just ask your view about, or your submission in relation to the previous 4 powers of attorney? In what sense was actual authority given on behalf of Spectacular? Would you be saying in relation to those 4 powers of attorney that the duomatic principle might have applied?
My Lord, yes, in that Mr. Mr. Costa's instruction was there on the actual authority of Mr. Byington.
And that was not formally given in any company resolution or shareholders resolution. So one's looking at something informal.
Yes.
So we've got duomatic applying to the actual authority. The question then is going to be, is it not, if we are against you in relation to ostensible authority in terms of the representations made by Mr. Costa, by Mr. Byington, the question will be, am I right in thinking whether duomatic can be applied to apparent as well as actual authority?
My Lord, yes, I think there are 2 related principles, related questions. The first is, can the duomatic principle be applied to apparent or ostensible authority as opposed to actual authority? I would say it's an unwarranted extension of the principle. But secondly, I say that the duomatic principle, in any event, applies in relation to bona fide and honest instructions. And here, what actually happened is that the instructions from Mr. Costa were not bona fide or honest.
It might be said against that, might it, The honesty that's been talked about is the honesty of the shareholders. In other words, you're looking in these cases, I think in Duomatic itself, we're talking about the honesty of the shareholders. We're not talking about, because it couldn't have risen, because this question about apparent authority, I'm not sure has arisen before. The dishonesty here is not the shareholders' dishonesty. It's the shareholders of Mr. Costa, who's a third party.
Well, yes, that involves a consideration of what the ambit of the exception is in relation to the nature of the instructions and what the meaning of bona fide and honest is. Now, because a company can sell property, but yeah, and if we go back to the words I cited in the extract from Parker and Cooper Limited, the transaction is inter vares and honest, and especially if it is for the benefit of the company.
Yes, but the transaction in question was a transaction by the directors. And so what Parker and Cooper seems to be saying is if the director's action or transaction is inter vares and honest, then the shareholders' consent is effective, though informal. I wonder if it's looking as such to the shareholders' honesty, but I think this is a matter which we should leave for further debate after the short adjournment. We will adjourn now. Thank you.